The defendant has a support obligation of $396 and a balance of $5,129.06. The last payment was received in June in the amount of $95.80. The defendant has contact on December 18th to report a new employer. The friend of the court would ask the court to order a monthly past due support obligation of $102, which is 2% of the total amount owed, and would bring the monthly payment to $498.
All right, so what is your current employment situation?
I just started new work last week at Petoskey Plastics out of Petoskey.
Okay. And how many hours are you typically getting there?
40 hours a week.
In front of the court, you indicated that the withholding order is in the process then?
Yes.
Okay. Sir, were you working, well, when did you last work before this job?
It was about 2 months ago. I did a week at another place, but I was having some health issues with my leg, and I got that taken care of. So now I'm back to work full time.
All right. And the front of the court indicated you have a balance that's a little bit over $5,000. Does that sound accurate to you, sir?
Yes, it does, Your Honor.
Is there anything else you'd like to say to me at this time?
Not at this time, Your Honor.
All right. The front of the court has asked that we increase your support amount to include that, obviously the back amount that's due. Otherwise, we never would get it. Do you have any response to that request?
No, I do not, Your Honor.
All right. Thank you. Ms. Hildebrandt, do you have any questions or comments that you would like to make?
No, sir.
Thank you. All right. Well, given the recent job and the status of the amount that is owed, I do think it is appropriate. And I would recommend that in addition to the monthly amount that the defendant pay an additional $102 per month, representing 2% of the amount that the arrears that is owed, bringing his monthly support obligation to $498. There's an income withholding order that is anticipated to go into place soon. For the court, do you think we should adjourn and set a new date just to follow up, or will you just set a date if there's an issue with the income withholding?
We could adjourn to maybe February 21st, and then we can remove that if the payments aren't coming in.
Okay. I think that makes sense. So we're going to also adjourn this matter to February 21st just to monitor that that income withholding order is in place and being paid on. So, sir, if, you might have a paycheck or two where that income withholding order is not taking any money out. If that happens, you should be making the payment directly. Okay.
Yes, sir.
All right. Any questions, sir?
No, Your Honor.
All right. And Ms. Hildebrandt, do you have any questions?
No.
All right. Thank you. Thank you both for appearing. And then again, sir, so if that income withholding order is in place, things are going smoothly, you won't have to appear on that February 21st date. Thank you. Mr. Young, can you hear me okay?
Yes, sir.
And Ms. Wordsmith, can you hear me okay? All right. I do need you to unmute, ma'am, so we can hear you.
Oh, there we go. Sorry.
All right. Thank you. We're here today on an objection to a child support recommendation. Is that correct?
Yeah.
Okay. My understanding is you both are requesting a change to child support. Is that correct, Ms. Wordsmith?
Yes.
Mr. Young, are you also requesting a change?
Yes.
All right, thank you. All right, Ms. Wordsmith. All right, so ma'am, you received a copy of the recommended child support. What is the reason you would like to have that changed to a different amount?
We are actually looking to terminate child support obligations from either party. We both care for our son when he's in when he's in our presence with us. If Tucker were to need anything at his dad's house, I would provide that, and vice versa. So neither of us are interested in child support from the other one.
Okay. And it looks like the recommendation indicated that Mr. Young has about 105 overnights. Is that correct?
No, we have him. It kind of varies back and forth. Sometimes he has him more overnights, but he's not picking him up till, 8:30, 9 o'clock at night when he gets out of work. I have our son more during his waking hours. And our son's special needs, so he requires a lot of maintenance.
Okay.
But we both have him a fair amount of time, and We just don't feel that either of us needs financial support from the other.
All right. Is there any state medical insurance or aid that
There is, yes. Our son has Meridian. I did put in the letter that I had written to the court that I'm happy to pay the. I do have a better financial situation than Michael does. I'm happy to pick up anything that the state would need as far as medical goes. That could be my responsibility.
all right, ma'am, so you would be okay with having a order that required you to pay that amount?
Yes, sir.
All right. Is there anything else you'd like to say, ma'am?
No, sir.
Do you feel that the request to reduce it down to just the medical cost, do you think that that will allow you to provide enough assistance for your child to meet his
Oh,
needs?
yeah, absolutely. Yes, sir.
All right, thank you. And are you making this request voluntarily?
Yes, sir.
And Mr. Young, is there anything that you would like to say regarding this objection to child support?
No, we're both in agreement and not having child support, and we both agreed with her paying the medical. I also offered that if I can, every other month, that I would also help pay it.
And do you agree that your child, even without the payment of support from one party to the other, will have his needs met?
Absolutely.
And that the two of you do share in expenses and the cost for meeting your child's needs?
Yes, we do.
And are you making this request voluntarily?
Yes, sir.
Friend of the court, as to the medical in this matter, do you see any issue with the plaintiff paying that medical amount?
I'm not sure if the obligation can be assigned to the states and choose the grantee, but we can try and see if it's possible. It just might end up being paid to the defendant since she's the grantee of the medical grant.
Okay. All right, well, we're gonna see if we can accomplish that. I would grant the objection. However, the medical cost still has to be addressed given the situation. The parties in this matter have indicated that they both provide time or provide for the cost for the child, that neither party needs additional assistance from the other party to meet the needs of the child. They both are making this request voluntarily, knowing what the child support recommendation is. From the court, any additional information that you need?
No, if we can assign the medical obligation to the state, then we'd follow up with the parties, let them know what the next status. So maybe if we adjourn the hearing just for a status conference on the medical support obligation.
Okay. All right. So we need to make sure, with the way the payee is set up, that it would work. It may have to be that Mr. Young is the payer, and then, obviously Ms. Wordsmith can reimburse that, or however the two of you want to handle that. But just paperwork wise, there might be some hiccups in the system. So I'm granting it, but we're going to also set a kind of a status conference date on February 21st, just to make sure everything went through smoothly. And friend of the court will be in contact with you also to keep you updated. Any questions, ma'am?
No, sir.
All right, Mr. Young, do you have any questions?
No, sir.
All right, thank you both for appearing. It does conclude your hearing, but ma'am, you're still muted, so we need you to unmute.
Very sorry, I'm not very used to it. I can hear you.
All right, no problem. Thank you, ma'am. And I've not seen Mr. Norris present in front of the court. What is the status of this file?
The plaintiff has a monthly obligation of $1,007 and a current balance on the account of $3,378.90. Last payment was received in September of 23 in the amount of $667.69. We're seeking court's guidance as to how to proceed.
Thank you. Ms. Stevens, do you have any questions or any comments that you would like to make?
No, Your Honor. It's right. I haven't received any child support since September.
Okay. The outstanding is $3,078, is that correct?
$3,378.90.
Okay. All right, thank you. Well, given Mr. Norris's failure to appear today, I will recommend, and the fact that he is several months behind, I will recommend the issuance of a bench warrant in the amount of $850 plus $100 in costs. Ms. Stevens, any questions?
No, Your Honor.
All right, thank you. Thank you for appearing today. You're all set. Yes, sir, thank you. All right, we are here today on a friend of the court motion in order to show cause, indicating that previously Mr. Warr was ordered to provide some information, and it sounds like perhaps that information has not been provided. Is that correct, friend of the court?
That is correct, Your Honor. On August 10th, we were here, and Your Honor recommended that he provide medical and income information to the friend of the court. Judge Mertz later made that an official order on August 28th, ordering the plaintiff to provide those documents, which have not been received today.
All right, thank you. Sir, what would you like to say regarding this matter?
Okay, so I couldn't get into the doctor until January 2nd. He wanted to review my medical chart due to the fact that I just became he became my PCP, and he's new to my case, and he wanted to review it before he signed any documents. So my appointment's on January 2nd at 10:45 a.m. I attempted to call Elbow In. They told me, the owner told me that I need to make a Paycor account, which is who we used to go through for our paychecks. And once I did that, it would not give me any information about the Elbow In. I'm not quite sure why. I attempted to reach out to Elbow In several times through phone. I even showed up once. He was not there. He was not available for questions. I asked him several times. No text back, no callbacks. Again, I was only there for 3 weeks. Like, I wasn't there for very long, so I don't know if they never put me in the system or what the situation is on their end. And lastly, SSI did provide friend of court 3 different times. I was told, because I called them asking for proof that I'm on SSI, and they themselves sent friend of court 3 different letters saying that I qualify for SSI benefits.
So you're saying that you currently receive SSI benefits?
Yes, sir. I have since 2009, and I have provided, and SSI has provided documentation stating that. I also have my court-appointed conservator present through Otsego County.
Did SSI send you copies of what they sent to front of the court?
They sent it to me at the beginning of the year, or I believe in January or February. They also send it to my conservator as well. And they have requested garnishment of wages 3 different times, and they've gotten the same letter back 3 different times. Friend of court, as in they.
Okay. Friend of court, any information that?
Just not so much if the question isn't if Mr. Warr receives SSI, it's if he has the ability to earn any type of income or work in addition to what he receives. SSI obviously wouldn't be included as income, so we just need verification that he has no ability to work, which would be completed or verified through the physician's form regarding disability before we calculate support as with a 0 for someone's income. We need that just to verify that even though they receive SSI, that they have no ability to work and earn income.
All right, thank you. All right, Mr. Warr, anything additional you wanted to say?
If I was able to work, why would I be receiving SSI benefits? If
Well,
I
were you
meet
receiving
the
SSI? Did you receive SSI benefits when you worked at the Elbow In?
Yes, but I also was paying $800 in rent in order to survive. I only make, I believe it's only 830 something. Monica can tell you exactly how much it is. I'm not 100% on the exact amount that I receive. But again, I can't live off of $36 a month. Nobody can.
Well, the
So I
issue
had no
was,
choice
the issue, sir, was, are you able to work at all? And you said that you were able to do some work,
Yes.
potentially. I don't know if that's changed recently medically or not, but we'll get to the bottom of that. So that's kind of where we're at. So I think the appropriate thing to do is, you said you have an appointment coming up in January. Is that correct?
January 2nd, yes. So in a couple days.
So I think what we'll do is adjourn this matter, set the matter before the judge. So we'll put you in front of Judge Mertz on I think March 4th, which would give time for you to have that doctor's appointment, get any records from them, as well
No,
as,
I did have an appointment
as well
before.
as if legs, if at the elbow in, might send you a W-2 at the end of the year, tax year also, so you might get that. So you might have a chance to provide that paperwork also. I would again continue the recommendation that you provide something from the doctor that talks about your ability to have any type of employment.
Yes, sir. I did have an appointment with my doctor, but he didn't want to sign it right away without reviewing my
Sure.
chart.
All right. Yeah, this is going to give you time to get that done. So, you know, you may have that appointment, get that paperwork, and not need to appear on March 4th. Friend of the court will let you know, but as of now, you would need to be back March 4th, and that would be in front of Judge Mertz to address the situation. Friend of the court, anything additional on this matter?
No, Your Honor, thank you.
All right, sir. Thank you for.
Excuse me, Your Honor, do we have a time for March 4th?
I think it's 9 a.m.
Okay, thank you.
And he will get sent the notice. Thank you. All right, we are all set, sir. You may sign off.
Excuse me, sir. Quick question for you.
Go ahead.
Okay, so I have a conservator. Do you guys need her information, like her address and whatnot, to send her paperwork?
I do not need that at this time, no.
Okay.
Friend of the court, do you think you need her address information?
We can have someone reach out if we do.
Okay, all right, we're all set. Parties can please unmute themselves. And Mr. Smith, can you hear me okay?
Yes, sir.
Thank you. And Ms. Nilsson, can you hear me okay?
Yes, sir.
All right, we are here on an initial hearing regarding custody, child support, and parenting time. Mr. Smith, you are the plaintiff, so I will ask you first. Do the parties have any agreements on those issues?
We do have agreement with parenting time. We have reached a compromise from the time I'd have filed, where we've been getting equal distribution for the kids.
Do the two of you currently reside in the same residence or reside separate?
Separate residents.
Okay, thank you. All right, so as to the agreement, are you going to share joint legal custody, do you know? Or what's the agreement?
I do believe that's what we are going for now, is joint legal, since the kids will be equally with both parents.
All right, so joint legal and joint physical, what is the custody arrangement as far as the amount of time each of you has with the children?
We've been doing week on, week off. So each month there's been 21 days per parent.
And are you switching on a particular day?
We've been doing at the end of the week on Fridays after school. So then that way it gives the other parent the weekend and then the following week.
Okay. And have you talked about holidays? Are you going to alternate those, come to your own agreement, follow the court schedule?
Right now, currently, we've been doing mutual agreement on holidays. We are in the works of still rotating.
Okay. Ms. Stilson, does that sound like the agreement the two of you have reached?
Yes.
Okay, and do you want the court then to make that a court order?
Yes, please.
All right, so I'm gonna go over again the agreement with both of you individually. Thank you. So sir, is it correct that you're asking this court to enter an order that would grant the parties joint legal and joint physical custody with a week on, week off custody arrangement, switches to take place on Friday after school?
Yes.
And you also, is it also true that the two of you are going to work out holiday time as the two of you agree?
Yes, Your Honor.
And do you feel this agreement is in the best interest of the children?
Yes, Your Honor.
Have the two of you discussed child support at all?
No, we have not, Your Honor.
Okay. What the court would do is do a child support recommendation that does not go into immediate effect. The parties have 21 days after that's sent to you to object to that recommendation if one of you feels there's grounds to do so. So the court will also order that the child support recommendation be prepared as part of this. From the court, have you received everybody's financials, do you know?
Yes, Your Honor.
All right. Ma'am, are you also asking the court to enter an order that grants the two of you joint legal and joint physical custody of the children?
Yes.
And Pairing time would be week on, week off, with exchanges to take place on Friday, and the two of you would share holidays as agreed. Is that correct?
Yes, Your Honor.
And do you feel this agreement is in the best interest of the children?
Yes, Your Honor.
Who currently has the kids in their custody right now?
I have them right now.
All right, so then they'll go to dad on Friday?
Yes.
Okay. Is that correct, sir?
The reason why Miss Stilson has the children was so she would have them for the holiday of Christmas for this year. We did talk that today I was going to get them back to finish my week for this week.
All right, I just wanted to clarify kind of whose week is whose week. So
technically,
your week definitely. This is Mr. Smith's week right now.
So I had went downstate last week on we left Wednesday, so he got them Tuesday night. So I had them he's had them since Tuesday night, and then I got them back on Christmas Eve night.
Let's do it the simple way. Whose week is going to start on Friday?
Miss Stilson.
Yeah.
Okay. So I'll just indicate in the order that mom's week starts December 29th. In the summer, are you going to continue the week on, week off?
Yes. I would prefer week on, week off.
Okay. Is there a particular time you want to exchange on Fridays, or simply as the two of you agree in the summer?
I'm not 100% sure. I mean, we could still do like the time frame when they get out of school, because that's how we've been doing it, is when they get off school, we go and pick them up after they're off of school.
We can either set a specific time, or we can just say it's as the two of you agree, and then the two of you can work that out. And if at some point you need a specific time set, you can certainly seek the court's assistance in that.
I'd prefer as we agree. So, because we do have schedules, different lives.
All right. Are you okay with that, Ms. Stilson?
Yeah, that's fine.
All right. Thank you. All right. So based on that, then the court will issue an order indicating the parties will share joint legal, joint physical custody with a week on, week off custody arrangement. They will share holiday time as agreed. Exchanges are on Fridays, after school during the school year, or as the parties agree if there is no school. And mom's next week begins on December 29th. And again, there will be a support recommendation prepared and mailed to the parties along with the paperwork from today. Do you have any questions, Mr. Smith?
At this time, no, I do not.
All right, thank you. Ms. Nilsson, do you have any questions?
No, sir.
All right, thank you both for appearing. Please let us conclude your matter.
I'm here.
Is Miss Baker Gray with you?
Yes, sir. She is right next to me.
Yes, I'm here, Your Honor.
All right, we're here today on a hearing regarding custody pairing time and support. What is the status at this time?
We were going to do a 50-50 custody, but if it's involved with child support, we do not want to do that.
All right. So the parties are still moving forward and looking for a stipulated agreement. Is that what you're indicating?
We are still together and there's really no need for custody, but if anything, we would do 50-50.
Well, I guess my question is, are you asking that this case proceed, or are the parties asking that the matter be dismissed, or are you seeking a custody order?
How does this work?
We're not sure how this works.
All right. Well, Ms. Baker Gray has filed a custody complaint. So if the two of you are together and don't want a custody order, you don't have to have that, or you can proceed. You can be together and still have a custody order.
We went through the courts and we got the ex parte and the PPO dropped. So I'm pretty sure that's probably what it's from. Well, I would probably recommend that it get dismissed because we don't need custody considering we're together.
Ms. Baker Gray, can I hear from you?
Yeah, I agree with Christopher and stuff. We are together as a couple and stuff, and we really quite don't need it. But if we can get the 50-50 custody being together without, having to like do any of the visiting or parenting time because we're together, like I just don't know how this works.
All right. Well, I'm trying to ask you, Jude, do you want to have an order in place or if you want to dismiss the case? You're the one who filed it, so you can make a decision if you are asking that the matter be dismissed, which would mean there would be no specific order. Or the parties can decide that they want to reach a stipulated agreement on an order, or you can have a hearing to make a determination as to those issues.
I think as right now, we can just dismiss this right now until we to figure out further.
All right, let me put you under oath just to get that on record. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, so Ms. Baker-Gray, you filed a complaint for custody. Is it true at this time that you are asking that the matter be dismissed?
Yes, Your Honor.
Are you and Mr. Phillips residing together?
Yes, we live in the same apartment that we got together as a couple.
Okay. Is it true at some point recently you had a PPO against him?
Yes, Your Honor.
And has that been dismissed also?
Yes, Your Honor.
And ma'am, are you making this decision freely and voluntarily?
Yes, Your Honor.
All right, thank you. Well, based on the testimony from the plaintiff, I would recommend it be dismissed.
All right, thank you, Your Honor.
Any questions, ma'am?
No, I do not.
All right. Mr. Phillips, do you have any questions?
No, Your Honor, I don't.
Thank you. Ms. Haskell, you are the plaintiff in this matter. Have the parties reached any agreement regarding custody and parenting time?
No.
Is that correct, Mr. Haskell? You do not have any agreement?
We had one previously, but things have changed and we no longer have one.
All right. Ms. Haskell, then, are you asking the court set a hearing and make a determination, or do the parties want additional time to see if they can reach an agreement?
We will not be able to reach an agreement from my belief going on.
All right, well, we can set the matter for a hearing. Ms. Haskell, do you intend to hire an attorney or represent yourself at the hearing?
I will myself.
Okay. And do you plan to call any witnesses or just provide testimony yourself?
I will have testimony myself. Probably have written statements if that's okay.
Well, I can't tell you what is and is not admissible, but there are rules of evidence. Typically, you need to have a person present to provide testimony.
Okay.
So do you anticipate then that you would have some witnesses?
No.
Okay. Sir, do you intend to call any witnesses or just provide testimony yourself?
Just provide testimony myself.
All right. I think then we could probably set your matter for a one time to see if we can get it completed in that time frame. The earliest I have a slot for that is March 13th at 11 a.m. We will send you a copy of the notice also, so you have that date and time in writing. Ms. Haskell, do you have any questions or anything additional you'd like to ask?
The only concern at that point in time is I am due to give birth at March 17th. So there might be a little bit of possibility I might be in the hospital determining how things are at that time.
Okay. Certainly. So obviously, yeah, if you are early or something's going on, just let the court know and we will give you a new date.
Okay.
All right. Mr. Haskell, do you have any questions, sir?
No.
All right. Thank you both for appearing. We'll see you back here then,
Yes.
hopefully on the 13th at 11 a.m. Hear me okay?
I'm doing okay. By yourself?
Good. Thank you. So Mr. Weber, you are the plaintiff, so I will ask you first. Have the parties reached any agreement as custody and parenting time?
This has been a really tough decision, honestly. My son is afraid right now. He's been afraid. So right now he's with me.
All right. So my question just simply is, do you guys have any agreement at this time that you want the court to enter as an order? Do you need more time to discuss those issues, or would you like the court hearing and have the court make some decisions?
I'd like to have a court hearing. But for now, I'm going for ex parte.
All right, well, if you want to file an ex parte, that's separate from what we're doing in front of me. That's a request you have to file with the judge. But this time you're indicating that there's no agreement and you would like a evidentiary hearing. Is that correct?
That's correct.
All right. At the evidentiary hearing, are you going to represent yourself or have an attorney?
I haven't decided yet.
Okay. Do you intend to testify just yourself or will you call witnesses?
I will have witnesses.
Okay. Do you know approximately how many witnesses you might have?
A handful at the moment.
Okay. Ms. Weber, do you intend to just testify yourself or have witnesses at a hearing?
I will have witnesses.
Okay. All right. So we'll give the parties more time than an hour. We'll give you a 3-hour time slot. The first date I can give you is February 14th at 1 p.m.
I'll be there.
Sir, do you have any problem attending that date?
No, that will be fine.
Okay. Mr. Weber, any issue with that date?
You said the 14th, correct?
Yes, so February.
February at 1 p.m.? Yes, I'm fine with that.
All right, that'll be an in-person hearing, just so you know, so that won't be by Zoom. You'll actually be here physically in the courtroom.
Understood.
All right, thank you. So we'll see the parties back here then on February 14th for an evidentiary hearing. The child in this matter is 8 years old and will be 9 years old at that time. Is that correct?
That's correct.
All right, so given his age, there will be a preference interview conducted with the child off the record. So I will need to make sure that he is also here that day. I will do that interview at 12:45.
Understood.
So we'll just make sure someone is able to get him here at 12:45 before the hearing. Generally, I think it's good then to have the child leave afterwards. So hopefully somebody can make a travel arrangement so he does not have to sit outside the courtroom until the hearing is over.
Of course.
Okay. All right.
Absolutely.
Thank you both for appearing. That does conclude the matter.
Thank you.
My bad. Shannon Susie?
Shannon Sosi.
Susie.
All right, thank you. And sir, if you are smoking, you need to, you're not allowed to do that because you are in a court of.
No, I done put that out when I came live.
Thank you.
Thank you. All right, we're here today on a motion regarding custody that was filed by you. Is that correct, Mr. Fennell?
Yes, sir.
Looks like the parties recently had a judgment put into place in November of this year. And sir, you're looking to change that order?
Yes, sir.
And in particular, what part of that order are you looking to change as far as the custody and parenting time?
Your Honor, I tried to sit down with the plaintiff and work out our differences. The court presumes an established custodial environment.
Hold on, Mr. Fennell. Mr. Fennell, I don't know if you're too far from your microphone or not, but you're, I can barely hear you.
Can you hear me now, Your Honor?
I can a little bit. It's not great. You were louder when you first signed on.
Okay, how about now?
That's good.
Your Honor, the plaintiff and I have been unable to work out our differences, and the courts presume an established custodial environment exists by reference. And I have serious concern of our child's environment, physical and psychological health, and overall well-being. And the current environment presents obstacles that prevents natural development and facilitates plaintiff influence to allow third-party boyfriend to custodial parent or child.
All right, one second, Mr. Fennell. We're not getting into all the arguments. I was just asking you what you wanted to change. So you're asking that you have the primary physical custody? Is that what you're asking?
Yes, Your Honor. I'd like the courts to consider giving me shared physical and legal custody to be able to pick up our son from school Thursday and have him till Sunday evening, an equal amount of time our child spends with mother and all third parties in his presence, unless court determines.
Right. So are you asking, so what other, hold on, sir. So your current order says that parenting time is as the parties agree. Are you asking for a specific parenting time schedule?
Your Honor, I'm asking for a change in custody, shared physical and legal, to so that way the plaintiff cannot frustrate visiting time or allow allow her boyfriend to custodial parent our son because he's around a lot of third parties in his environment.
All right.
Your Honor.
I get what you're asking.
Can I
Hold on,
speak?
ma'am. Okay, so everybody, it's a lot easier that we all talk. Once I ask you to give me the floor to talk, everyone's going to have their time, but just yelling things out randomly is not going to be helpful. So Mr. Fennell is requesting a change in the custody. This is a recent order, so there are some hoops he's going to have to jump through to show that it's appropriate to change the order. But at the same time, the order says parenting time is as the parties agree, and a party does have a right to seek specific parenting time. So that would be part of his request also. Ms. Crow, what would you like to say?
Your Honor, since Jason has been out, he has created nothing but problems. He literally has a problem with the fact that I moved on and got a boyfriend because I couldn't stand him.
Okay. All right. So again, today's not the day to get into, you're not making any decisions today.
No,
We're just hearing, but hold on, ma'am. All right. So we're not getting into the facts of the case, just what is being asked. So Mr. Fennell is seeking a change in the custody as well as some type of specific parenting time. So what we'll do is set the matter for a hearing because I get the impression that Ms. Crow, you do not agree with that request. Is that correct?
No, sir, because he's created a lot of problems with the hospital and the school.
All right. So you do not agree. You don't need to get into the reasons why at this moment. That would be for the actual hearing. So we'll set this matter for a evidentiary hearing. Mr. Fennell, how many witnesses do you anticipate calling, or are you just going to testify yourself?
Your Honor, I have at least two witnesses.
Okay. And Ms. Crow, do you intend to just testify yourself, or do you also intend to call some witnesses?
I have a couple witnesses I can call.
All right. Well, I'm trying to decide if we set this matter for 1 hour or for the longer 3 hours. I think given that there is a recent order in this case, we will say 1 hour hearing. We need an additional hour. We can always add additional hour. So the next available time I have for the hearing date is March 20th at 11 a.m. And that is a in-person hearing, just so you know, that will be in the courtroom.
Would you be able to send notification to my CPS workers she would like to attend?
No, but you can, ma'am. We'll send you a copy of the court order.
Okay,
the
thank
court
you.
notice. So we will notice this for a hearing on March 20th at 11 a.m.
And what do we do about parenting time until then?
Man, there's an order that's in place. I'm not changing that order. Whether or not that order gets changed will be decided on March 20th.
Your Honor, I'd like to say, is there any way that you can amend the order just for visiting time, so that way there's less interactions with the mother and the mother's boyfriend?
I cannot do that until I have a hearing on all the issues to decide if it's appropriate to amend or not, and we go from there. So we will address all those issues on March 20th at 11 o'clock.
That's a really long time, Your Honor. When my son is exposed to lots of third parties, I should be allowed to have an equal amount of time with my son, and it's very frustrating when she uses the visiting time.
All right, sir. Again, we're not hearing the arguments today. It's not scheduled for that. This is just a motion hearing to see what's going on and then to give you guys a date. That is the first court date I have available to hear your case. So we will hear your case on March 20th at 11 o'clock. All right. Thank you both for appearing today. That does conclude the matter. We'll see you here on March 20th. And Ms. Susie, if you could please unmute and let me know if you can hear me okay.
Yes, I can.
All right. Thank you. We are here today on an initial hearing regarding custody, parenting time, and support. Mr. Susi, you are the plaintiff, so I'll ask you first. Do the two of you have any agreements on those issues?
Yes. The kids' mother and I, we have discussed it. We would like to set up where the legal custody is me, but we will have physical custody of the kids with parenting time of every other holiday. Some of the kids are out of school. And
all right, so you faded out a little bit here and there, so I've heard some of it, but I'm missing parts of it. So let's start with this. So you're going to have the legal custody, is that correct?
Yes.
All right, and then physical custody, is that joint physical or do you have the primary physical?
I would have primary physical custody.
All right, and what would be the parenting time then for Miss Susie?
For Miss Susie, we have discussed that she is more than welcome to come to the state of Michigan where the kids reside with me. Visit with them on the weekends when they are out of school on their breaks, any special activities, whether it's my daughter's gymnastics, basketball games, football games, when the kids are on their breaks, their, Christmas, Thanksgiving, winter break. We would share every other holiday. So she would have the kids on Mother's Day, Father's Day. We would split Thanksgiving every other year. She would get them during the summer when they were on summer break.
All right, again, some of that faded out, so we're gonna try and go through it a little bit more. What I took from what I could hear is that there's an agreement that when she comes to Michigan during certain times, she can spend time with the kids. Is that correct?
Yes, Your Honor.
All right. And then you said alternate holidays. Is that a holiday schedule that the two of you are working on, or are you following the court's holiday schedule?
It would more than likely be on our holiday schedule. I mean, I don't know what the courts up here have. Like this
Well, it
year,
alternates a lot of holidays, and when people are out of state, sometimes that's difficult to make sure that that's happening. So,
right. The main holidays is Thanksgiving, Christmas. We would alternate those. Like this year, I had them for Christmas and I had them for Thanksgiving. Next year, she would have them for Christmas, Thanksgiving. She could have them during their summer vacation. She can have the visitations when they are out of school on their week vacations.
okay. How about spring break? Is there a discussion on that?
Spring break, that would fall under one of the times that she would be able to see the kids, if that's what she chooses.
Okay.
But we've also discussed that she would have to come to the state of Michigan, and the kids cannot leave the state of Michigan until she has a permanent residence and proper transportation for the kids.
Okay. Do you have any discussions regarding child support?
I have originally put into the court system that I didn't want alimony nor child support. I'm capable of taking care of the kids. We agreed to where she would send me $100 a week. According to paperwork that I have filled out, that because my children are on Medicaid, I cannot stop the child support process.
Okay. Ms. Susie, what's been outlined, is that an agreement you are asking the court to enter?
Yes, I do agree with the parenting plan that we have set. I do want us to try to see what we can do about the child support because he does agree that he doesn't want it. We've agreed on a specific amount to send each week. My job that I have is I'm getting more hours now, but it's not considered a full-time job, and I don't want to end up in jail and then lose what I'm trying to do for my children.
What we'll do with child support is, the court is required to make a child support recommendation. So we'll issue a child support recommendation. You'll both see what that amount is. And then either one of you or both of you can object to that. If you reach some other type of agreement, we can have a discussion to see if that's appropriate or not. So that's how we would handle the child support portion. Well, one part of calculating child support is to try to determine how many overnights you're going to have with the children. And I'm not sure how to put a figure on that because it sounds like your overnights is just kind of based on how often you return, not necessarily set in stone as to one point to return. Do you have anything else you can say to me about an idea of how many overnights you would have with the kids?
That I don't know. I am only 4 hours away. So like he said, whenever they're out of school or things like that, I do plan on getting a motel room where they stay and they can stay with me in that room. I don't know if that counts as an overnight with me, but
Yes.
I'm only 4 hours away. So at any chance that I'm allowed, I will be up there and they can spend whatever they're allowed with me.
And then do you anticipate having them in the summer?
Yes.
Okay. All right, so you're in Napoleon, Ohio, is that correct?
Correct.
Okay. All right. So I'm going to go through it all with you one more time. I'll start with Mr. Sir. Is it correct you're asking this court to enter an order that gives you the sole legal and physical custody of the minor children?
No.
Yes.
Parenting time for Miss Susie. She would have the summer break, as well as she can come to Michigan when the kids are, anytime they are out of school during the school year, and have parenting time here in Michigan. Is that correct?
Yes. Just until she has an established residence in Ohio, then I will agree to allow the children to travel place of residence.
All right. So during their breaks, she's free to have the kids. If she has an established residence, they can go to Ohio. If not, she can exercise that time in Michigan. Is that correct?
Yes.
And then the parties are going to do holidays as they agree. Is that correct?
Yes.
And you feel this agreement is in the best interest of the children?
Yes.
And the two of you discussed when her summer parent start and end or not?
You broke up, sir. Can you repeat it?
Have you reached an agreement as to when the summer parenting time would start and end?
Not an exact date or time. We did have some snow days this year, so we will have to figure out when the last day of school will be, and then she's more than welcome to get them that following weekend or as soon as she would like.
All right, thank you. Ms. Susie, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And ma'am, are you also asking this court to enter an order that would give Mr. Susie the legal and physical custody of the minor children, and then you would have parenting time?
I have a question about that. Does that mean that I lose all rights to the kids? I'm confused about that.
Well, legal custody has to do with major decisions as far as where the kid's going to attend school, any major medical procedures. If one party has sole legal custody, they do not have to consult the other parent regarding those decisions. You still have legal rights to the children. You still have the right to their school records, their medical records, and those type of things. But he would be the one, he would not have to consult you to make those bigger decisions.
I would like to be involved in their medical decisions. I do feel like it, because they haven't been, CPS hasn't taken them away from me. So I've agreed on a lot, but I do want that I would like that, at least with medical decisions, that I be consulted. That's all I ask.
All right. So you're asking to have, well, that would be called joint legal custody. He would have the primary physical custody based on obviously the custody and parenting time plan. But your request is to have joint legal custody.
Correct.
Is that correct?
Right. I do agree that right now he does need primary physical custody. The kids do need to stay with him. I do not have proper housing or transportation. All I'm asking is that I be more involved in like medical decisions and things like that.
So Mr. Susi, as to legal custody, requesting joint legal custody, are you in agreement with that or not in agreement?
Yes, Your Honor, I am in agreement with that because I was not under the full understanding of the difference between legal and the physical. So after you broke that down, yes.
Okay, perfect. Thank you, sir. All right, so Ms. Susi, then you're asking the court to enter an order that gives the parties joint legal custody, but dad would have the primary physical custody, correct?
Correct.
And then you would have parenting time, as we've discussed. You would have the majority of the summer. The parties are going to work out what dates that happen, as well as then you would have time when the kids have breaks during school, long weekends, and you would agree that you would not leave the state with the kids until you have stable housing. Is that correct?
Absolutely.
And the parties are also going to share holidays, is that correct?
Correct.
And do you think this agreement is in the best interest of the children at this time?
Absolutely.
All right, thank you. Friend of the court, do you need any information from the parties as far as a child support recommendation?
Yes, I believe we need the defendant's info and then also to address the DC case.
Okay. So Ms. Susi, you do need to provide the appropriate financial information to the friend of the court so they can prepare a child support recommendation. As indicated, that will be a recommendation that the parties can object to. They'll have 21 days to file an objection on that. So Ms. Susi, I don't know if you have the paperwork that gets sent out or not, because it looks like maybe you've had a couple address changes. So have you received that paperwork from the court?
I have not received all of my court paperwork. I have received here in Ohio. For whatever reason, all of that child support paperwork over was sent to a different address, and I did not receive that.
All right. So the front of the court will send that out again, and you have 21 days to return that information. Also needs to address the fact that this matter was originally filed as a custody case, and then at some point a divorce file was also opened. Is that correct, Mr. Susi?
Yes.
All right. And is it the party's intent to move forward with the divorce?
Yes, it is. We're going to continue moving forward with the divorce.
All right. So in that case, then that this matter then should proceed under the DM file instead of the DC file. So that DC file will simply just be closed out and become part, and then the custody issues will be resolved as part of the DM file. And that's where that agreement will be a part of. Anything additional from the court?
No, Your Honor.
Mr. Susi, do you have any questions?
Yes, I do. I need to put on record that my mailing address is not my living address, and I need all of my paperwork that's sent from the court sent to P.O. Box.
Okay. Anything else, sir?
No, that'll do it, sir.
All right, thank you. Ms. Susi, do you have any questions or anything else that we need to address?
I just want to make sure that we are like in a year or so after I do get established, we are able to come back and change things from the way they are now.
Well, custody orders are always open to modification. There's certain rules about how to modify and evidentiary facts that need to be dealt with when modifying, but they are orders that can be modified with some certain restrictions.
Okay.
You can consult attorney if you want to know all those specifics, but any other questions, ma'am?
No, that's it.
All right, Mr. Thank you both for appearing with us. Can you hear me okay?
Yes, I can hear you.
All right, thank you. We are here today on an initial matter regarding custody, parenting time, and support. It's also been brought to my attention that there's potentially a second file in another county involving the parties. Ms. Staff, you are the plaintiff in this. So you filed here in Otsego County, is that correct, ma'am?
Yes, Your Honor.
And is it also correct then that Mr. Staff filed in Charlevoix County?
Yes, Your Honor.
Okay. Has that matter been in court yet or not?
No, Your Honor.
At the time of filing, were the parties living together or living separate?
Living separate.
All right. Is that correct, Ms. Staff?
Yes, Your Honor.
And where were the children living, or were the parties sharing custody of the children when the case was filed?
She was currently staying with her dad because they weren't allowing me to see her at the time.
Okay. When was it, man, that you had last had custody of the child, an overnight with the child?
I have her from Monday to Sunday this week.
Okay. Prior to the filing of the case, was there a time period where you did not have any parenting time?
Just the 1 week from the 11th to past Thanksgiving.
Okay. The two of you currently have an agreement as to the custody and parenting time?
Yes, Your Honor.
Yeah, we
You do? Okay. And Ms. Staff, what is that agreement?
Sunday to Sunday.
So week on, week off with Sunday changes?
Yes, Your Honor.
Okay. And any agreement regarding holidays?
Not at this time. We decided that we could both be civil enough to be together on holidays if need be.
Okay, so kind of just do holidays as the two of you agree. Obviously, if the two of you at some point don't agree, you can always seek a specific order or just choose to follow the standard holiday schedule. So, ma'am, is it correct that the parties would share joint legal and joint physical custody?
Yes, Your Honor.
Okay. And sir, do you agree with that?
Yes, Your Honor.
All right. So we can't have an order in both counties, obviously. The two of you have an agreement now, so we can certainly put an order in this case. And then I assume the other county would just dismiss the matter there. Do you have any issue proceeding that way, Mr. Staff?
The divorce is actually going to be happening in Charlevoix County.
Oh, you filed a divorce matter. Okay. All right, I missed that. So, ma'am, you filed it as a custody matter. He filed it as a divorce matter. And sir, is there a court date for that or not yet?
Not at the moment because I have not gotten confirming that she has gotten her papers. She says she's gotten her papers for the divorce and custody order, but I still haven't gotten anything back in the mail with a signature to hand into the court. So my lawyer did go to Antrim County, and she is trying to get served through them so we can get it moving forward.
Okay. All right. Well, then I think given that lack of service or proof of service at this time, this matter would have precedence, but obviously it would probably be absorbed by the DM in Charlevoix once that case gets rolling. Correctly, you're asking this court to enter an order that grants the parties joint legal and joint physical custody with week on, week off parenting time, exchanging on Sundays.
Yes, Your Honor.
And the parties will alternate holidays as agreed. Is that correct?
Yes, Your Honor.
And do you feel this agreement is in the best interest of your child?
Yes, Your Honor.
Are you changing at a particular time on Sundays right now?
Not right now, just after my parents get out of church.
Okay. So right now, the exchange time is just as agreed. I mean, we can certainly do it that way. Obviously, the two of you are always free to make a specific time. And are you meeting somewhere in particular to exchange the child, or does one parent drive? How are you guys handling the transportation?
Since as of right now, I'm the only one with a vehicle. I kind of drop her off and pick her up.
Okay.
My parents all drop her off and pick her up as well.
All right, so we'll just say transportation as agreed. Again, obviously, if there is any change at some point, you can always put specific language in. All right, so are you also asking this court to enter an order that grants the two of you joint legal and joint physical custody?
Yes, Your Honor.
And the parenting time would be on a week on, week off basis with exchanges taking place on Sundays. Is that correct?
Yes, Your Honor.
And do you feel this is in the best interest of your child?
Yes, Your Honor.
Who has the child now, and who does she go to on Sunday?
I have her right now, and she goes to Eric on Sunday.
Okay. So we'll indicate that as part of the order. That way we just have it on confirmed as to the Sunday to Sunday rotation. Ms. Staff, do you think there's anything else that needs to be addressed?
Not that I know of right now.
All right, Mr. Staff, anything else that you think needs to be addressed?
No, Your Honor.
Front of the court.
I think we need their addresses.
Okay. So that's the child support front of the court. I was thinking perhaps we reserve that to let that DM case catch up.
Yes.
Okay.
And then do the parties stipulate for this order to be consolidated or transferred?
Okay, sure. So, Ms. Staff, once that other matter starts to proceed, the divorce matter proceeds in Charlevoix, do you consent and agree then that this agreement would become part of that case, and this case here would be closed.
Yes, Your Honor.
All right, and Mr. Staff, do you agree to that also?
Yes, Your Honor.
All right, and we're going to reserve doing a child support recommendation until it wouldn't make any sense for this county to do it since Charlevoix is going to take that over. So we're not going to prepare that recommendation at this time. But Ms. when Howard, we this is prepare your motion regarding support. Is that correct?
Yes.
And you are seeking post-majority support, which is support after a child turns 18 until they graduate. Is that correct?
Yes.
Okay. And Mr. Howard, are you objecting to that request?
No, Your Honor, I'm not. But I really think we're wasting the court's time because I don't think we needed to be in court to do this. But I'm unable to get a hold of Mrs. Howard. She has me blocked on everything. I just
let me just put her under oath and ask her a few questions. I think you do have to go through the process here. Ms. Howard, so Ms. Howard, the two of you have one child who is about to turn 18 years old. Is that correct?
Yes.
And is that child still regularly attending high school on a full-time basis?
Yes.
And when is it expected that he will graduate?
I turned it in and it was May something.
Of next year?
Yes.
Or yeah, 2024, correct?
Yes.
And does that child live with you?
Yes.
All right, Mr. Howard, do you have any questions that you would like to ask Ms. Howard?
Well, I guess what I would like to add is, I mean, if there's any way that I can get a hold of you without us having to come to court and me taking time off of work, because I never
All right,
objected.
so hold on, Mr. Howard. This isn't a platform for the two of you to have discussions.
Oh, I'm sorry, sir.
I asked if you had any questions for Ms. Howard on this issue.
No, sir.
All right, thank you. All right, so based on the testimony of Ms. Howard, the court does find that the child in this matter is about to turn 18 years old. He is regularly attending high school full-time, has a reasonable expectation of graduating from high school next May 2024, and is living full-time with Ms. Howard. Therefore, I would grant the motion in order that the post-majority support continue until the end of May 2024. Ms. Howard, do you have any questions?
No, sir.
All right, Mr. Howard, do you have any questions?
Just a statement, because it was brought up that he is living full-time with Ms. Howard now. Actually, he was just here for 6 months with me full-time. I don't know how that matters or if it matters at all. But
all right. Well, certainly moving forward would be the issue. So if during this time, after this post-majority support is ordered, if things change with his living arrangement, you can file a motion to change the support.
Thank you.
All right, you're welcome, sir. All right, thank you both for appearing. That does conclude this matter.
Thank you.
Thank you, Your Honor.
For the front of the court to address custody, parenting time, and support. Matter is set for 11:30. Is now 11:34. It does not appear that either party is present. I don't see anything in the file that would indicate a resolution. I think there's good cause to adjourn to see if the parties would then appear at a new hearing date to get a status of this matter. So the
Excuse
court
me, Your
will
Honor.
adjourn this. Yes.
We had two telephone numbers just as you were speaking showed up and I just brought them in. So that might be them.
All right. Perfect.
Hello, my name is Ethan Robertson.
Hi, my name is Ashley Robertson.
All right, thank you. Just 1 minute. All right. So in regards to the Peters matter, then the court would ask the matter be set for a new initial hearing in about 30 to 60 days, and the parties be sent new notes. The parties are present by phone. Ms. Robertson, you are the plaintiff, so I will ask you first. Have the parties discussed custody and parenting time and support? And if so, have you reached any agreement on those issues?
Yeah, with everything, we have reached all agreements. That's why we went with an uncontested divorce route. And we have listed everything that we want and are comfortable with custody arrangements and parenting time, just everything in general. Yeah.
All right. And that's, you said you filed that document with the court?
Yes, yeah.
All right, I do see a parenting time attachment that was filed with the paperwork. Are you asking that the court adopt that as the schedule?
Yes, Ethan and I have agreed that he will have Alistair weekends, and then on holidays, we will discuss that amongst ourselves based on our schedules, what works best for us.
Okay. So the parties are going to share joint legal custody, is that correct?
Yeah.
And I guess I was unclear of the physical custody. Is that joint physical custody, or does one of you have the primary?
I have Alistair majority of the time, but we have joint physical custody. We want joint physical custody as well.
Okay. Then what is the parenting time breakdown then?
You're asking what the parenting time is right now. It's been ever since Ethan and I have been separated. I have had Alistair majority of the time during the week. He has had him on weekends.
Is that the plan moving forward? Is that he would have every weekend and you would have the weekdays?
Yes, Ethan will have weekends. I will have weekdays.
All right. And do you have specific times on when the weekend starts and the weekend ends?
Usually we go by Friday night at 8, he picks him up, and then Monday morning at 8, he picks him up. But sometimes that changes on his work schedule.
Okay. And holidays, have you reached an agreement regarding holidays?
Yes, based on his work schedule, sometimes we're cordial enough to where we said that once holidays come up, we just want to discuss that amongst ourselves, to where like we are cordial enough to where we can be together for a holiday or separate. It just depends on what we discuss for that particular holiday.
All right. So we just would indicate that holidays would be as the parties agree.
Yes. Yeah.
Okay. And has there been any discussion on the issue of child support?
Yes. So far, Ethan has been helping as much as he can, but we have come to the agreement that he wants. We have come to the agreement that $600 a month is fair, and that's also what we have listed in our divorce paperwork as well.
Okay. So as to support, what happens is the front of the court will prepare a child support recommendation, and if the two of you, if one of you doesn't agree with it or both of you don't agree with it, you can file an objection. Then you would have to come back to court to address that issue. And at that point, you can indicate if there's a different agreement that you want the court to adopt as far as child support. And ma'am, do you feel this agreement is the best interest of your child?
I'm sorry, I didn't hear you.
All right, and ma'am, just to go over it again, you're asking the court to issue an order that grants the two of you joint legal and joint physical custody. Is that correct?
That is correct.
And the general outline of the parenting time agreement would be that you would have the child during the week, dad would have every weekend, roughly from Friday at 8 p.m. until Monday at 8 a.m., but that is also dependent on dad's work schedule. Is that correct?
Yes. Sometimes on Mondays, it's a little bit later in the day based on sometimes he has, he works at night, so he sleeps in a little bit, and I've just come to terms with that, and it's fine.
Okay. And you also are going to share holidays as agreed, is that correct?
Yeah.
And you feel this agreement is in the best interest of your child?
Yeah.
As far as the transportation, the pickup and drop offs, do you guys have a set plan, or is that just something you agree to based on how things are going at that time?
Just based on how things are going at that time.
All right, so we'll say transportation is as the parties agree. Mr. Robertson, if you could please unmute. All right, sir, and are you also asking this court to enter an order that grants the parties joint legal and joint physical custody of the minor child?
Yes.
Would you agree that mom would have parenting time during the week, and then you would have parenting time on weekends, Friday night until Monday morning?
I do.
that the two of you will also share holidays as agreed,
I do.
and that transportation would be as the parties agree.
Correct.
And do you feel this is in the best interest of your child?
I do believe that it is in the best interest of our child, Your Honor.
Thank you. Front of court, do you know if you need any information from the parties?
I don't think so, but I do think we need an updated address.
Thank you. All right, so as indicated, the front of the court will prepare a child support recommendation. And again, the parties will have the right to object to that if they do not agree with that objection, and then come before the court to address any changes that they would like to see in the child support recommendation. The court will also send the parties a copy of the stipulated order from today regarding custody and parenting time. Ms. Robertson, do you have any questions?
I don't have any extra questions.
All right, thank you. Mr. Robertson, do you have any questions, sir?
No, I do not have any extra questions.
All right, thank you both for appearing then. That does conclude your matter, and you may sign off.
All right, thank you, Your Honor.
Thank you.